All rise. The Court of Appeals, Division 1, is now in session.
Good morning. Please be seated. This is the time set for argument in the matter of State of Arizona versus Mary Ann FOLE. Our criminal number 170804. Each side will have 20 minutes within which to present their argument here this morning. Appellant may reserve some portion of that for rebuttal, but it's up to you to keep track of your time in that regard. We have read the briefs, we've been through the record, we've conferenced the case. We're familiar with the underlying facts and the issues, so please take that into account when you make your arguments here today. We're recording these proceedings, both by audio and video means, so we would appreciate it if you identify yourself and your client for that purpose when you approach the podium. And with that, appellant may proceed.
May it please the court. Good morning. My name is Craig Raymond. I'm here on behalf of the appellant, Mary Ann FOLE, who is currently in custody in the Arizona Department of Corrections. I would like to point out to the court that her husband, Mr. Norm FOLE, is here in a support role seated in the front row. Judges, thank you for this opportunity today. I would reserve approximately 5 minutes for rebuttal. Your Honors, I would like to start out by pointing to, I think what we're trying to say here is that the jury verdict in and of itself essentially proves our point. When this case first came forward, the initial allegation of theft or misappropriation was close to $400,000. That was pre-trial. That amount was whittled down to $177,000 by the time the trial commenced. The jury in this case came back with a verdict on the theft count of between $25,000 and $99,000. Percentage-wise, the way that works out versus the $177,000 is that's anywhere between, on the low end, at $25,000, 14% of what the state was saying she misappropriated.
Counsel, isn't that a standard winnowing that goes on in the course of being accused, being investigated, being charged, and being tried?
Certainly, Your Honor, it is. But I think the overarching issue is the fundamental fairness into which I would submit my client was entitled to know exactly what the foundational allegations were first.
So you have to come up with the final number first and then go somewhere from there?
I'm not suggesting necessarily final, Your Honor. I'm suggesting by analogy. The analogy I'm trying to draw is that on the high side, the jury found 58% if it found that there was theft in the amount of $99,000. The question becomes, even if we look at the high end of 58, what happened to the other 42% out there?
Does that make her conduct any less criminal?
Well, it doesn't necessarily make it. I think it goes to the issue of prejudice, though. I think it goes to the issue of fundamental fairness as far as notice. And that's what we've been complaining about throughout our briefs. This case was highly unusually processed. And to the extent the court will allow me to draw an analogy, if I'm going to sit down and charge a sex crimes case involving a minor child, number one, I'm not going to let the mother do the forensic evaluation or interview. I'm not going to allow the prosecution to wait 3 years to turn over that evaluation or before I have someone from Child Help interview the child. I think my client is entitled to know exactly what transactions. And, Your Honor, if I may cite, I think Judge Adelman knew this. Judge Adelman on March 29, 2016 of this record ordered the defense, ordered the state shall disclose a list of criminally charged transactions on which they intend to proceed to trial.
They had kind of an inherent problem in this case with that, didn't they? Wasn't a reference made at one point to the fact that your client's the one that was supposed to have all the documents?
Well,
She's the one that was supposed to have prepared all the records that nobody could find?
Correct. 3 years after she was terminated.
So they adjusted the number to what they were able to prove once they had all the paperwork uncovered, and that's your objection?
Part of it, yes, Your Honor. But in addition, I think what should have happened is a full-blown forensic accounting to begin with. In other words, as a prosecutor, do you put your name on this indictment? Do you have a reasonable likelihood of conviction based on the alleged victim putting together the numbers, which our expert at trial, through the course of 4 reports, clearly called into question her accounting practices. Again, this is 3 years down the road from her termination.
Let me ask you, I understand what you're saying, but we're here after a guilty verdict and a sentencing. Help me understand better how the arguments that you've presented so far fit in the kind of 3 or 4 legal issues you've raised on appeal.
Yes, Your Honor. Your Honor, we, first of all, primarily, we're submitting, as a prosecutor, when you sit down and you decide, how am I going to get this item of evidence in? If it's not charged, your only other avenue is through 404. I need to file a 404 and ask the court permission. I'm not going to be so bold to walk into court thinking I can go into all this other evidence in the middle of a trial, in the middle of a jury, and think I'm going to walk in with my evidence. So, Judge, first of all, that prior hearing needs to happen. There's a gatekeeper function that's not only going to ensure fairness for my client, it's going to educate my judge as to exactly what the issues are.
What's your best case for the proposition that a 404B, not a 404C, but a 404B hearing is mandatory in every case pre-trial?
Your Honor, I did cite the one case. It is in my opening brief. There is language in that case, and I'm sorry I don't have that cite memorized, but it is in my opening brief that there should be a pretrial hearing.
Always in every case, evidentiary hearing on a 404B, again, not 404C, but 404B, that's your position?
That's my understanding, Judge, and the reason being is, first of all, by analogy to this case, we have to know, first of all, did the other act happen by clear and convincing evidence? In this case, we don't have clear and convincing evidence that it was her responsibility not to pay the payroll taxes. We don't have clear and convincing evidence in this case that it was my client's, that my client had anything to do with siphoning the lawsuit money in this case. And I think it's what's interesting, I may submit, Your Honors, is that even if we're going to switch this over to an intrinsic argument, there's no component of that clear and convincing evidence like there is in a straight 404B.
So were you saying that at the time the trial started, the court had failed to prove that it could present testimony regarding the elements of the charged crimes?
Your Honor, I'm going to point the finger at defense counsel. Defense counsel should have, at that point in time, requested a hearing. There should have been an evidentiary hearing, and there should have been expert testimony on these various other allegations.
So we're into fundamental error? Is that what you're arguing?
Yes, Your Honor, we are into fundamental error. And, Your Honor, we would submit, as to fundamental error, it does go to the very foundation of this case. Again, there is not compelling evidence that Ms. FOLE, number one, it was her responsibility to pay the payroll taxes and she didn't do it. Her testimony and our expert's opinion was that this was part of the switchover in 2008 to Chase, and we thought that this was being taken care of. There is, with such poor accounting practices and procedures, there was no internal data from RMFC that tells us that cash was misappropriated. There were, first of all, the company expands.
Are you saying that the total absence of cash throughout the period that she was the accountant, there was no inference can be drawn from that? The fact that they never received any cash? Never had any cash deposits?
I'm suggesting that when we instruct the jury that the state's evidence must be more powerful than just by a preponderance of the evidence, it must be by beyond a reasonable doubt that yes, Your Honor, that needs to be specified. This is not a criminal robbery case. This is a financial transaction case where my client has due process rights to know exactly each and every transaction, each and every amount that is alleged to have been attributed that she put in her pocket. Yeah, very much so. I think she's entitled to that under both substantive as well as procedural due process. And I think that's where this case got away. Again, I think the question becomes, this jury comes back with a finding of between $25,000 and $99,000. What are the, we're never going to know what they exactly relied on. But, our position all throughout is that the state never showed on all these other issues, first of all, that my client did anything wrong. The payroll taxes, depositing checks from other business. Her testimony in our expert report showed that Ms. FOLE outlaid over $18,000 of her own money to this company. This company that she worked for, that's a company of 6 people that she works side by side.
Counsel, you've been passionately arguing that the admission of this other act evidence was error, right? Didn't defense counsel below stipulate to the introduction of all this evidence?
Your Honor, I believe there were occasions, and I'm not going to try to correct the court because I do not recall exactly. He may have said, yes, I don't object, but there were occasions where he did object. But, Your Honor, my understanding was whether he objected or not, we still are entitled to make an argument that this is, in fact, fundamental error the way this proceeded.
Wait. Please define the fundamental error for me.
Yes, Your Honor.
If he stipulated to the admission of the exhibits that were used, that were testified to, that were presented at trial, explain to me where the fundamental error is on the court allowing the testimony in regard to those exhibits.
Your Honor, if my memory serves me correctly, I believe there were colloquies with the court where defense counsel objected, and if I may have a moment to point to the record.
It's your time.
Your Honor, it was, I'll supplement the date and time on rebuttal, but there was an exchange where the prosecutor went into, the defense objected to certain other acts, and I don't think we were specifically talking about the exhibits, as the court has asked, being introduced, but the notion of some of these other acts, and the prosecutor to the judge said, Judge, we're not relying on this as a fraud count or a theft, but it's part of the symptom of a disease. That's the portion of the transcript that I'm referring to where I do believe the defense attorney did stand up and object to the introduction of this. The court, at the end of that colloquy, made a comment essentially to the effect of, well, he went into it on his case in chief. I would have to pull the exact language, Your Honor, but I understand what the court is saying, that the defense counsel may have, in fact, stipulated to certain exhibits coming in. Nonetheless, I still believe, notwithstanding any Rule 32 issue, that I think it's disingenuous for the prosecutor to proceed on this 3 years into the case, tell the defense, I'm going to rely on these checks and these credit card transactions for the theft, and then the other payroll increases for the fraud. So I'm not sure how we can allow the state to go into these other acts that don't necessarily support the ones that were charged. They don't prove the other acts that were charged. Two things. Number one, why weren't those other acts charged to begin with? And number two, I submit that the state has offered no explanation for how those uncharged acts proved or facilitated the charged acts. Thank you, Your Honor.
Are you reserving the rest
Yes,
of your
Your Honor.
time? All right, thank you, counsel.
Thank you.
Good morning. May it please the court, Michelle Hogan with the Attorney General's Office representing the state of Arizona.
Counsel, I think I just heard that you didn't charge her with enough charges.
Correct.
You had way more testimony and you shouldn't have gotten the testimony, and you did without additional charges that you didn't bring. Is that what I just heard?
I believe that's the argument they were trying to make, that somehow the charges of fraudulent schemes and theft didn't encompass these acts, but the deposits which he referred to form the very basis for these charges, along with the other deposits and transactions that the state proved at trial. Going into that, they raised disclosure. However, the state disclosed more than 3 years before trial FOLE's bank account records, which showed all these deposits. And then over a year before trial, the state disclosed an expert report describing every transaction in detail, or every transaction and deposit that the state intended to prove at trial. And this expert report was stipulated to in evidence at trial. The expert report included these checks. So FOLE deposited checks payable to the victim's business into her personal account. FOLE deposited the victim's checks payable to a business vendor into her personal account, and deposited money collected from the victim's business into her personal account. And all of these were on the expert report and were part of the charged act. So therefore, this evidence was intrinsic because it directly proved the charged acts of fraudulent schemes and artifices and theft. They contend that somehow the state limited itself because it sent an email prior to trial that did not identify these particular transactions. But in light of the stipulation to the expert report and the disclosure of the bank account records, there was no limitation of the evidence the state could prove at trial.
Counsel, do you recall the exhibit number of that expert report?
The expert report was Exhibit 115.
115, thank you. And did that expert testify at trial then?
Yes, the expert testified at trial.
That was subject to cross-examination?
Yes. So the checks and the lawsuit money are no different than the other fraudulent expenses that the state proved at trial, and these included the misappropriation of cash, personal purchases on the business credit card, ATM withdrawals, as well as unauthorized payroll increases. All this evidence together was intrinsic to prove both those charges.
Counsel, can you tell us about the prosecutorial misconduct allegation? Can you address that for us?
Yes. Here, FOLE has failed to demonstrate error, let alone fundamental error, because no misconduct occurred. The prosecutor's statement during opening that I wish it had ended there did not constitute vouching.
What did that even mean?
In full context, the prosecutor was providing a timeline that emphasized the various ways that FOLE stole from the business. I don't think that the use of the word I there was a personal assurance that witnesses would testify truthfully or putting the prestige of the government. So the prosecutor would describe one way that FOLE had stole from the business, then in 2008 she stole this way, in 2009. So I wish I had ended there was just an inartful way of describing the different ways that she stole from the business.
Kind of a segue, wasn't it?
Correct.
And so she wasn't saying anything about, as I understand anything about the weight of the state. She was saying, if I had my wish, she wouldn't have done the rest of what she did.
Correct.
But counsel, as you point out, it could have been phrased more artfully in an opening.
Right. With the worst, could have avoided the use of the word I in that context. This prosecutor's second statement during opening that based on all this, the state charged the defendant with fraudulent schemes and artifices and theft. That statement also did not constitute vouching. Again, the state was summarizing the evidence and describing how this evidence supported the charges. And the jury already was well aware that the state had brought these charges because the trial court read the indictment during preliminary instructions. So I don't think that was intended to put the prestige of the government behind this charging document. Turning back to FOLE's failure to make payments to the IRS and the lender, this evidence was also intrinsic to the charged act of fraudulent schemes and artifices because it occurred contemporaneously with and directly facilitated that charge. Evidence established that FOLE was responsible for making those payments, both the victim's testimony and other employees' testimony, and she admitted so to the IRS herself. FOLE quickly depleted the business account by stealing checks and cash And to continue her ongoing scheme of embezzling from the business, she decided to stop making these payments and to conceal it from the victim. So another employee even testified that she instructed the employee to conceal a visit from an IRS representative regarding the business's failure to make its IRS tax withholding payments. So her decision to stop making these payments, along with the concealment of it from the victim, facilitated her scheme, because if the victim had known that the business did not have enough in its business account to satisfy its financial obligations, the victim would have reviewed the accounting records and quickly uncovered FOLE's scheme. So therefore, it was necessary and facilitated her scheme to defraud. And even if this court were to find that just that piece, the failure to make the payments, was not intrinsic, it satisfied the admissibility requirements under Rule 404B. First, it was relevant to rebut her claim that the victim approved all of these charged transactions and deposits. And it was the victim provided clear and convincing evidence through her testimony and bank account records that these acts occurred. So, going back to relevance, I think a reasonable jury could conclude that the victim would not have allowed FOLE to take over $150,000 from the business account for personal use if that money would have otherwise been used to satisfy its obligations to the IRS and to its lenders. So that's why it was relevant. Additionally, the probative value of that evidence was not substantially outweighed by unfair prejudice. The mere fact that the business had unpaid obligations would not cause the jury to decide the case on an improper basis.
Was a 404B instruction given in the final jury instructions?
No, Your Honor. None was requested, and it wasn't reviewed under 404B.
How about you've heard appellant's counsel speak of the thought that a pretrial evidentiary hearing is required for every 404B issue. What's your response to that?
No, because we can look on review and determine whether it would have satisfied anyway. So that would be the first prong, whether error occurred. So we could look through the factors and see whether this evidence would have otherwise been admissible under Rule 404B. And then, after we determine whether it was admissible, the court would move to prejudice to determine if the admission of that evidence caused any prejudice if we decided it was error. And here, even if we were reached the prejudice analysis, here the admission of that evidence would not have caused her any prejudice, given the strong evidence of guilt at trial. And turning to our other claim of prosecutorial misconduct, the prosecutor's statement in closing rebuttal argument that documentation did not exist was a reasonable inference from the evidence and served to rebut her defense. FOLE claimed that all the expense checks and other business transactions were approved. Part of her responsibilities as an office manager included maintaining receipts and supporting documentation for every business transaction. So the fact that these did not exist for the charged transactions is because she used the money to fund her lifestyle and she never created the supporting documentation. So it was reasonable for the prosecutor to infer that this documentation actually didn't exist. None of the statements that the prosecutor made either throughout the trial constituted misconduct, but even if we were to reach prejudice, none of these statements were of such a dimension to deny FOLE a fair trial. And lastly, it wasn't addressed, but FOLE has failed to establish that the trial court committed fundamental prejudicial error when it imposed a statutorily authorized sentence for a Class 2 felony. The court gave its reasons for imposing a prison term on the record, and nothing in the record supports FOLE's claim that the trial court relied on inadmissible evidence to reach its sentencing determination.
What position did the state take on the sentencing? What the sentence should be?
I believe that the state requested the presumptive term, which was 5 years for a Class 2.
You got less than the presumptive.
Correct. She got a mitigated term, 4 years imprisonment.
And aggravators have been proven or found by the jury, I should say. Is that correct?
Correct, yes. Several aggravators were proved, and the trial court also mentioned that it considered the mitigating evidence on the record. This court has no further questions. The state asks that it affirm Foley's conviction, sentence, and probation term. Thank you.
Thank you, counsel.
Again, Your Honor, I think what the state is assuming without clear proof is that my client did anything, misappropriated any of those monies. The assumption is she did. And by throwing it all in under one indictment, that's what we are submitting is improper. As to the prosecutorial misconduct claim, for the prosecutor to stand up in closing argument and say it is Ms. Foley's responsibility to either find, and I disagree with my colleague's characterization of what the prosecutor said in closing. He said she was responsible for this. She could have gotten it. She should have had it. I'm paraphrasing. She could have gotten this documentation herself. Is that not a clear burden shift to Ms. Foley to undo herself from these allegations, these charges?
Don't you think another inference is the prosecutor was saying that it was the defendant's employment responsibility to create and keep these records and did not do so?
Your Honor, I think a fair reading of the entire transcript doesn't make that conclusion clear.
She's not the accountant. Let's be real clear here. The inference is not that she's the accountant.
She's one of the accountants in part. She's one of the record keepers. She's one of the activity organizers and funders. Her role was a utility infielder, basically. But her testimony and what our expert opined is that, so even on the cash issue, our expert points out there's no QuickBooks analysis that took place inside this company there's no QuickBook records, there's no policies and procedural manuals within this company, there's no evidence of what took place before my client came on board in 2008 to be able to determine, number one, was this improper? And then we get to the actual records themselves. We submit that the record as a whole shows it is in no way clear that what she did was misappropriate money. There is not enough powerful evidence to suggest that's what she did or misappropriated. Again, she wrote Your Honor, she wrote an $8,000 check to the company, two $5,000 checks to help cover payroll and various other expenses throughout her tenure. So, I think it's a stretch to say that we have clear proof that these other acts, these other categories can lay at the feet of Ms. Foley, that she was responsible for them.
Isn't this, I'm sorry, this just sounds to me like a jury argument, arguing that the state has failed to meet its burden of proof.
And I get back to my analogy. If I'm going to sit down and charge a sex case involving multiple years of sexual abuse, and why do we have the 2-wit sections in the indictment on a sex case? 2-wit, the first event, 2-wit, the last event, the event in the middle, the event at the ball yard.
Well, counsel, this isn't a sex case, number one. Number two, it sounds to me like there were competing expert analyses and reports that were presented to the jury and argued to the jury, and the jury got to decide whether the evidence supported the charges or not. So where's the legal error?
Well, the legal error is, I think it's reflected in Judge Edelman's ruling of March of 2016, where he told the state, he ordered the state, you better identify what transactions you're talking about. And the prosecutor did that to an extent. He categorized certain things, and he labeled them. The checks were theft. I'm sorry, Judge. The stolen cash and the unauthorized payroll increases were theft. The fraud was the fraudulent credit card transactions, and then the insurance check issues. But that was it. That was all he did at that point in time. And I submit, without knowing Judge Edelman's mindset at that point in time, that what he was suggesting is this individual has a right to a fair trial. She has a right to know exactly what's coming down the pike ahead of time, not 3 years into this. And then on top of that, just the view from 30,000 feet, the prosecutor at one point in time says, I'm not going to turn over my expert report until I see yours. That's fundamentally backwards. Where was the Mesa Police forensic examination, forensic accounting? Do we allow the state to go forward without such an accounting? In other words, our expert, Mr. Evans, drafted 2 reports before Mr. Tribe even got around to drafting a report. Shouldn't a prosecutor rely on an expert opinion in a financial case like this to support their charges? Why is it allowed that they can come in the middle of this and say, well, here's what it is. Oh, by the way, we're going to go with these additional uncharged acts. If you thought they were wrong, why didn't you charge them?
Let's just assume for a second that all of what you say is true and it's error. Why was it not invited error? Based upon counsel's failure to object or in fact stipulate into evidence the very documents and points that you're now contending is error.
Your Honor, and I think I would direct the court's attention to my opening brief where I made reference critiquing my colleague at the trial court saying that there are, I believe, to be Rule 32 issues on this. So to the extent it's invited, Your Honor, I don't have an exact response other than to encourage the court to look at the entire presentation of this trial, the pretrial issues, and that's why I raised it, the pretrial issues. So, Your Honors, again, I think the defense did all it could to raise questions about the validity of the accounting, the validity of the allegations of theft or fraud. Your Honor, Your Honors, we're asking that this conviction be reversed. Thank you very much for your time.
Thanks to both counsel for the briefing and argument in this matter. We'll take it on the case under advisement and issue a written decision in due course. That we're adjourned.